Good morning, everybody.
Milord. May I mention, Milord, one matter?
Yes.
Milord, item number 15. Milord, there was direction, Milord, the Additional Chief Secretary Revenue to appear. Milord, if the order is not complied with, Milord. Though, Milord, the region order has been passed, but we could not file our affidavit, Milord. ACS is here with me. So I was only praying, Milord, it will be taken up in the next week. But I will be filing my affidavit, Milord. Because, Milord, budget session is going on, so he has to go to, Milord, the assembly. That's why I am making him prayer, Milord.
Show cause has not been filed.
Not, Milord. Late evening, Milord, the order yesterday it has been filed, Milord, though the claim has been rejected. So, Milord, will examine it. So, I will be filing, Milord, the so cause in course of day, Milord.
Mr. AG2, learned AG2, Mr. Sachin Kumar submits that though the order has been complied with, order under offense has been complied with, and a reasoned order has been passed yesterday, but the same could not be brought on record. Stop. The show cause containing the reasoned order is being filed today. Stop. However, in view of the order dated 3rd December 2021, 4th February 2022, the opposite party number 2, namely so and so, is present. Stop. Having regard to submissions made by the State Council, let the matter appear on next Friday. So cause be placed on record. Presence of the OP number 2 is dispensed with.
From the benefit of this, under the heading for orders will be taken.
Your Lordship, may I mention, Your Lordships?
Yes.
Yes, Your Lordship, the number has not been registered yet, Your Lordship, but I'm praying for next Friday तक हो जाता है, Your Lordship, अगर Your Lordship allow कर देते mentioning तो appellant is a Your Lordships.
Are you mentioning an appeal which arises out of the recent judgment rendered in the
Yes, Your Lordship.
case?
Yes, Your Lordship. Yes, Your Lordship.
By you, after the filing, you do the necessary removal of defects, etc. And if you mention it or give the mention slip to the court master even on Thursday, it will be listed on next Friday, but with the number.
Yes, Your Lordship. Oblige, Your Lordships.
Very well.
For orders will be taken. Item number 1 contains CB 677 of 2019.
Your Lordship, I am appearing for the petitioner, Your Lordship, in this case, Your Lordship. Your Lordship, order has not been complied as per the direction of the Honorable Reed Court, Your Lordship.
There is one defect. Remove that defect.
Your Lordship, defect number 2 we have removed, Your Lordship.
Number 1 may be made. Respondent number 1 may be made. So it is stated that respondent number 1 has made party in proper So you mean to say that the state of Jharkhand through its chief secretary, the name of the chief secretary need not be stated?
We have made party respondent. We have made party, Your Lordship, respondent number 1.
No, you have made party, but the office has pointed out that the party name should be there in a content petition. The concerned opposite party name should be there, the incumbent of the office. Anyway, you remove that defect. We will call for a show of the others.
Your Lordship, so cause has been filed, Your Lordship, in this case.
Your Lordship, I'm appearing on behalf of the state, Your Lordship.
Okay. What's the status of compliance? Rejected?
Your
Yes,
Lordship, it
Your
was
Lordship,
rejected. Your Lordship, there was a
One at a
direct.
time.
Yes, Your
Your
Lordship.
Lordship, there was direction to promote the petitioner, Your Lordship. In spite of the direction, they have rejected my claim, Your Lordship. Kindly see page 14, Your Lordship, of the order.
Yes, I've seen, and in fact, now you need to, if the petitioner is aggrieved, you can assail it in a fresh proceeding.
Your Lordship, there was no any direction to consider the representation, Your Lordship. There was the direction to kindly, Your Lordship, permit me to read the order, Your Lordship, of the read court, Your Lordship, at page 14.
Okay.
They have flouted the direction of this honorable court, Your Lordship. And in spite of the direction, they have rejected my claim, Your Lordship.
Very well. In that case, we'll consider you remove the defect within 1 week and let it come under admission.
Your Lordship, in the meantime, we'll file a additional show cause, Your Lordship, since this previous show cause was filed in the year 2019. And we took the plea in that show cause that since he was not eligible, since there was no post available. Since it was filed in the year 19, so till now, maybe there was a post and he may be promoted, Your Lordship. We'll file a fresh show cause, Your Lordship, in this matter. What is the current status of the claim of the petitioner, Your Lordship?
Learned counsel for the petitioner, Mr.
Ravi Prakash
Shubham
Mishra.
Mishra. Ravi Prakash
Ravi?
Mishra.
Yes.
1 week time to remove the surviving defect as under. Stop. Office to place the file for removal of defects and inspection on requisition being made within this time. Then counsel for the state, Mr. Ravi
Shubham.
Prakash Mishra. Oh, Shubham. Achha,
Shubham Mishra, Your Lordship.
Yeah, Shubham.
Shubham submits that earlier a show cause was filed. Stop. However, he may be allowed 2 weeks time to file supplementary show cause since the last show cause was filed in August 2019 itself. Accordingly, matter will be listed after 2 weeks under appropriate heading.
Obliged, Your Lordship.
Right.
Yes.
Item 2, CMP number 896 of 2019. This motion is secondly for the petition.
Who is appearing for the state? Petitioner state. Any state counsel?
My lord. Lord, though I am not appearing in this case, but on behalf of the state I am here.
So it will remain unattended. It's a CMP of 2019. There are 7 defects still remaining. Mr.
Lord, I
Mithilesh
appear
Kumar
on behalf of
Singh
the yes, madam.
appears for the petitioner state. You are standing counsel.
GA4 Miller.
GA4 appears for the state and is allowed 3 weeks time to remove the following and prays for 3 weeks time to remove the surviving defects as under. Stop. Time as prayed for is allowed. Let the name of Mr. Mithilesh Kumar Singh, GA4, appear in the cause list henceforth for the petitioner's state of Jharkhand. Stop. If defects are removed, list the case under the appropriate heading.
Obliged.
Item number 3, contempt civil 1 of 2019. Mr. Ranjan Kumar Singh for the petitioner.
Yes, my lord, sir. I am appearing in this case, my lords. The order of this honorable court has, in fact, not yet been complied with. The order is at page 20, my lord.
Mr. Singh, two defects are there. It's under heading of orders with defects. So, first of all, address on the defects.
My lords, I in
Authentication.
fact authentic, my lords.
Two weeks time is allowed to learn counsel
My,
for the petitioner to remove following surviving defects of his to classify.
my,
If defects are removed, will be under appropriate.
my lords, oblige, my lords.
Obliged.
Item 4,
Correct.
criminal offense, SJ 94 of 2022. Mr. Abhishek Kumar for the appellant, Mr. Prasant Pallo for the rest.
My lord, in this case, my lord, there are some defects, my lord, we will remove in course of the day, my lord.
Is it possible? There are 8 defects.
No, my lord,
9.
no, my lord, all are very formal, my lord, we'll do it today itself, my lord. All are formal, do it today itself, my lord. Or by Monday, my lord.
Do it by Monday.
I'll do it by Monday, my lord. In the meantime, my lord, the matter may be admitted and LCR may be called for, my lord, so that I can file an application for bail, my lord, under 389.
First legible copy duly certified. 339.
So far as pages are concerned, my lord, it was in the electronic mode, my lord, which was filed. The objection was there. Subsequently, my lord, the physical filing has also been made, my lord. Therefore, the impugn order is there, my lord, with respect to that part, my lord. That defect may not survive, my lord.
Are you aware of the defects?
Yes, my lord, I have got the copies, my lord.
So, some of the defect, like 9.2 says, there appears execution of wakalatnama by person other than appellant also.
No, my lord, that appears to be, my lord, that is not correct, my lord. The person that should not be there, my lord.
So you remove these defects by Monday at the earliest, and this after you remove the defects, it will come under proper heading on next Friday.
The time would have been saved if all the LCR could have been called, my lord.
No,
I will, my lord, that is my prayer, my lord. If your lordship,
LCR called on next Friday after it is defect free.
yes, my lord, therefore, my lord, I was submitting, my lord, if it all, because the first LCR is to come, then only, my lord, the bail application of all the convicts will be heard, my lord.
True. So therefore, don't force things unless the case is ready and defect free.
My lord, I am giving an undertaking, my lord, by Monday we will remove all the defects, my lord. Your lordship may record our statement, my lord.
What's the urgency? I mean, 1 week more?
Yes, my lord, the appellant, my lord, he is about 78 old, my lord. Therefore, I was praying, my lord, so far as that part is concerned. All
Maybe, but the lower court records will also take at least few days time, 1 week, more than 1 week time to come.
Not saying, my lord, the matter will definitely come after Holy, my lord. But in the meantime, if at all it is being went to the lower court, my lord, the instruction, my lord, it will be prepared because there is a voluminous record, my lord, in the present case. It is not as such, my lord, it will come in the normal course, my lord.
No, that we understand that.
Yes, my lord, therefore I was praying, my lord, if at all the LCR may be called for, my lord. I undertake, my lord, I will remove by Monday, my lord, all the defects, my lord.
No, you better remove the defects. There are 9 defects. Better remove it. We'll keep it on Friday. Then we'll call for the LCR.
Oblige.
And senior counsel for the appellant, assisted Mr. Anil Kumar, assisted by Mr. Abhishek Kumar, undertakes to remove the following surviving defects by Monday. Stop. If defects office to place the file for removal of defects on right position and on being made within this time. If defects are removed, listed on next Friday under appropriate heading.
What is the name of
Who appears for the CBI?
the office of ASJ? It's Prashant Pallav.
The name is already appearing.
Much okay.
Item number 5, criminal of SJ 95 of 2022. Mr. Devar,
On behalf of appellant Malaj. Malaj, there are
Yes.
5 defects. In that, 3 defects we have already removed, and 2 defects, they are minor defects. Malaj, in course of the day, I will be removing it. Malaj, in meantime, Malaj, the matter may be admitted and the LCR may be called for Malaj.
The office will report whether the defects have been removed. You will have to remove it today also as you undertake.
Yes,
So
Malaj.
then
Today,
let next Friday let it be listed. How many defects are there now?
altogether 5 Malaj.
Which defects are surviving? But I 9.4 and 9.5. Yes. Then counsel for the appellant, Mr. Devarsi Mandal submits that defect number 9.1 and 9.3, 9.1 and 9.3 have been removed.
Lordship, 9.2 has also been removed, Malaj. Yesterday
Wait,
we have
wait.
filed.
Wait. Office reports that defect number 9.2 has also been removed by filing typed copy of pages number 22 to 26. Stop. However, 2 defects 9.4 and 9.5 are still remaining. Stop. Then counsel for the appellant undertakes to remove it during course of the day. During course of the day, it won't be possible because it's not functioning in physical mode, and after the order is passed, then only you will get the file. You do it by Monday.
Monday, Malaj.
By Monday. Stop. Office to verify. If the defects are removed, let the case be listed on next Friday under appropriate heading. For the CBI, Mr. Prashant Pallav, ASJ.
Paradise. Item number 6, CP number 2 of 1996, Mr. Masu Kumar Mehta, author.
May I please, Your Lordship? My Lord,
Yes.
in view of last order and in view of
Yes.
the order dated 17/4/2021, nobody turned up to apply the order of the court.
So their earnest money was in the form of a check.
They have not approached to this court, neither to the official liquidator, that why the case is not being taken up. And therefore, I think that all they have deposited in the nature of check. Had it
So
been
that
the nature of bank draft,
that check check or bank draft may have expired by now.
Yes, my lord. And check also, the validity of check is not there, my lord, now.
The misfortune of the auction exercise of this company is still continuing.
Lordship.
Yes.
It appears that this time some bidders would be seriously interested. Then you suggest a course, keep it on next Friday. How to proceed? This auction will have to be declared as scrapped or over. Fresh proceedings may have to be undertaken.
Yes, my lord. One report has been filed on 18/12/2021, my lord,
Yes.
in which,
That is about,
yes, that is on the record, my lord.
that is about inspection carried out of the assets of the company by the bidders.
No, thereafter, the official liquidator praised before this honorable court that EMD amount of the, if any submitted by the bidder, that may be allowed to be returned back to them.
Have
Without
they
no-
have they have they written a request letter like that, or you are?
No. But they, if their EMD amount by way of check or draft will be here, will be in the office of the official liquidator. Otherwise, a direction may be issued that they may take away their EMD amount by way of check or draft, what they have submitted before.
You see, Mr. Mehta, it could be possible, except say Mr. Abhay Prakash, who has been appearing and following up this case for one of the bidders.
Lordship.
The other bidders may not be aware of the proceedings of the case now, that it is being taken up. So why can't the official liquidator make a call or through email inform the prospective bidders to convey their intent, and if they are interested, then the whole process of opening of the bid, respective bid and some compliances on their part can be deferred for the time being, taking into account the 2 years of COVID-induced delay. This
Yes.
will this will obviate the necessity of a fresh auction exercise and scrapping of the present auction exercise.
Then let the case may be fixed for 11th, my lord. By that time, we will inform by Monday through email to everyone.
Lordship, I agree.
Yes, Mr.
Lordship, since in terms of the order, last order, my company was supposed to file the audit report and the income tax. Now my company was newly incorporated. So far, they are providing me say 1 year audit report and 1 year income tax. Now I had requested, since in the last affidavit which was filed, an IA was filed, Your Lordship, seeking that they are also looking for some prospective investor in his company. So I have said you at least provide me the agreement with the prospective company so that they can provide the investment. Now we have already deposited the EMD amount that through check, Your Lordship, and 5 lakh through by a bank draft. Now that was already there. So we are interested to participate in this auction. Is the only delay which is there because of this nature, Your Lordship. Yesterday they had given me a telephonic call, so I was requesting for a week, 2 weeks time, so that in the meantime I can file also.
So this court will at this stage not make any remarks upon
No, Lordship. True. Let the company regulator, yes.
But let all the bidders who had participated be informed through the official liquidator.
Yes,
Lordship.
And we can give them some more time instead of next Friday, information to the bidders and their preparation and coming back again if they are interested. So we can
Then let
keep
it be on
it
25th.
Yes, Lordship. Yes.
Yes.
And instead of checking, Lord, they should deposit Lord draft.
the official liquidator inform them accordingly to renew their earnest money in the form of check or draft, whatever they have submitted.
Yes.
And if interested, they have to file this documents which they were asked to do. So all these, the official liquidator will inform them within this time.
We will inform, my lord. We will inform.
Lordship, in this case, I am on behalf of a prospective bidder, Lordship. He is interested in buying the whole property, Lordship. I was paying for some time so that we can file our IA and deposit the 30% amount, Lordship.
So you have not yet submitted a bid. You just want to participate now.
Lordship. Since there was so much delay due to COVID, Lordship,
The case is being adjourned. Whether your bid will be entertained or not, that's a separate matter. But if the case is being adjourned and you want to file an IA like few others have filed earlier,
Lordship,
it is up to you. The court did not make any remarks.
we will file our IA, Lordship.
Official liquidator, counsel for the debtor, Mehta submits that none of the bidders have turned up or complied with the order dated 17th April 2021 after the matter was adjourned on 18th February 2022. Stop. Subpara. It appears that the bidders may have lost track of the proceedings of the case due to the long interregnum for reasons of lockdown during the COVID period. Stop. It is therefore deemed fit to direct therefore the official liquidator would take steps to inform the bidders on their official email address / phone number, etc. About the progress of this case and the next date fixed, so that the interested bidders can make necessary compliances and appear on the next date before the court. Stop.
Really okay.
They may also be asked to renew the negotiable instrument or the document. They may also be asked to renew the check, demand draft, or any other instrument through which they have deposited the earnest money. Stop. At the time of making the bid. As let the matter appear on 25th March 2022. Stop. The official liquidator would endeavor to undertake this exercise by next Friday, so that the bidders may get to undertake the compliances.
Yes, my lord. Highly obliged.
Lordship, kindly my appearance may be noted for employment for an organization, Lordship.
Appearances through the court master.
Obliged, Lordship.
Next date is 25th March, Lordship.
Yes.
Obliged.
Item number 7, CMP number 713 of 2019, Mr. Mohammed Yahya for the petitioner.
Your Lordship.
Yes.
Your Lordship, instant CMP has been filed for restoration of arbitration appeal number 3 of 18. In this case, Your Lordship, there is delay for condonation of which I had filed an IA. There is delay of 303 days in preferring the instant restoration application, Your Lordship.
Mr. Pratyush, you are appearing for.
Yes, Milords, I am appearing. Milords, the IA was filed, Milords, after a further delay of 508 days, and there is no explanation with regard to that as to why, under what circumstances, they could not file it. After filing the CMP for a further delay of 508 days, 508 days, Milords. So total delay, Milords, would be 303 plus 508. Now, Milords, if Your Lordship sees, the explanation, only cursory explanation which has been given is in para 9 to 11, that somehow he lost.
How much was the delay in preferring the restoration petition? At that time,
303. 30 days was the time he filed it after 303 days delay.
33 days or 300 days?
303 days delay, my lords, in filing CMP.
And thereafter, further 500 days.
508 days, my lords, in filing the limitation petition. Further delay. Of five.
So
And there is no whisper.
This petitioner is not going to get the benefit of the order passed in the suo motu petition by the apex court, because the period of limitation had expired much before the start of the lockdown.
Yes, sir. That is there, Lordship.
In IM Lords para 9 to 11, they say that it is submitted that due to some personal difficulty engagement, the petitioner appellant lost his contact with his lawyer and could not informed about dismissal of his case. That after long gap about the after long gap, the petitioner appellant contacted his conducting lawyer on telephone. Then only he was informed about the dismissal.
Yes.
That is all there, and there is no further explanation of what 508 days delay was there on account of what. It was 303 days delay, Lords. It's a long period of time.
Appointment of an arbitrator.
Arbitrator, Lords.
Not against an award or a order passed section 34.
No, your lordship.
No, Lords, as regards the appointment of arbitrator is concerned, they have filed the application for appointment of arbitrator after 5 years of the contract. The contract, there was a sale deed.
No, that we do not want to get into the merits.
Yes.
But because of the inordinate, unexplained delay, this court is not inclined to condone it.
I was praying outside your lordship, outside your lordship, if my learned friend will agree, this matter will be sent for one day before Jhalsa lordship, if the matter is settled, as dispute is in relation to some money dispute and in relation to transaction of some lordship or purchase and sale of land.
No, Lords, I don't have this, sir. Lords, I don't have any such instruction.
No. What I am saying is that you can go for a pre-litigation mediation, but not at the instance of the court where there is such a long delay.
Your lordship.
Outside the court, you can settle it. Lord Learned Counsel for the petitioner, Mr. Mohammad Zaid Ahmad and Mr. Pradyus Kumar appearing for the opposite party. Both OP number 1 and 2. Stop. The restoration petition this petition seeks restoration of arbitration application number 3 of 2018, which stood dismissed for default on 25th October 2018 on account of non-compliance of the peremptory order dated 11th October 2018 on failure to remove the surviving defects within the time prescribed. The CMP petition, the restoration petition was preferred after a delay of 303 days. Stop. For condonation of which interlocutory application number 815 of 2021 has been preferred after a further delay of 500 days.
508 days.
508 days. Stop. The CMP was instituted on, the restoration petition was instituted on 23rd September 2021, while the IA seeking condonation of delay was filed on 11th February 2021. Stop. Learned counsel for the appellant, petitioner, taken the court through the averments in the interlocutory application at para 9, 10 and 11 to explain the delay in filing the application for condonation of delay. Stop. Reply to the IA has been filed by the opposite parties strongly objecting to the prayer for condonation of delay. And counsel for the opposite party, Mr. Pratyush Kumar, submits that there is no explanation worthwhile for explaining the worthwhile for condoning the delay of 508 days even after filing of the CMP petition, CMP, after 303 days of its dismissal. Stop. This shows that the petitioner has never been diligent in prosecuting the case. Stop. Learned counsel for the opposite party has also sought to draw the attention of the court on the merits of the arbitration application, claiming that it has been filed, that the request for arbitration was made after a delay of 5 years from the date of the alleged cause of action. To further prove his point that the petitioner has not been diligent enough at all. Stop. However, this court is not going to be drawn into the merits of the contention of the parties on the arbitration application. Stop. As at hand, the present application for restoration of the arbitration application is suffering from a delay of 303 days, and further, the interlocutory application for condonation of delay has been filed after 508 days. Stop. The only explanation furnished in the interlocutory application is that because of personal difficulty and engagement of the petitioner, he had lost contact with his lawyer and could not be informed within time. Stop. Such an explanation could have been a basis to explain the delay in filing the restoration petition. But after filing of the restoration petition, there is another 508 days in filing the IA for its condonation. Stop. In this restoration petition, a plea has been taken that there were no willful laches or negligence on the part of the petitioner or the counsel, under which the case stood dismissed for default, since it was completely beyond the control of the petitioner. Stop. This court, upon consideration of rival submission of the parties and the principles laid down in this regard by the judgments of this apex court and this court, does not find any cogent application to condone the huge delay in preferring the restoration petition. Stop. Accordingly, IA number 815 of 2021 seeking condonation of delay in preferring the instant restoration petition is dismissed. Stop. Consequently, the CMP also stands dismissed.
For admission. Item number 8. Content Civil 214 of 2013. Mr. Amish Kumar Tiwari for the listeners. Mr. Vikas P. Suprasad for the.
I am appearing for the state, my lord.
Just a minute. I will just break for 2 minutes so that the camera position is adjusted.
My lord.
Please wait for 2 minutes.
हैं? 2 मिनट में आएंगे तब तक एलपीएस देख लीजिए पैराग्राफ 6 है वही हम तो खोज रहे थे लिखा नहीं था इसमें ₹110 आगे से लागू हो गया।
Yes.
Yes, my lord, I am appearing on behalf of petitioner in this case.
Yes.
Lord, as per the last order, my lord, we have filed the wakalatnama of the substituted legal year. The,
Yes.
Lord, the petition, IA petition number 491 of 2022 has been allowed on 18 to 22. My lord.
So that I can see the order sheet is before me. So as far as I remember, on that day the court had expressed that the contempt is not maintainable before this single bench, because there has been a modification of the order by the learned division bench.
My lord, subject to my lord's appreciation, my lord, I may be allowed
Yes,
to, my lord,
Mr. Tiwari, please first acknowledge that whether this was the discussion on the last date when the case was heard on 18 December.
My lord,
Thereafter, you can proceed to convince the court today also, but since on the last day on 18 December, this was the opinion of the court, and you said that one of the petitioners has died, so therefore please allow us to make a substitution. Therefore, the matter was adjourned.
my lord.
Now, do you want to convince the court today again that the contempt is maintainable against the before the learned single judge?
My lord. If my lord permits me, my lord.
No. I had devoted quite sufficient time, as far as I remember. The State Council, you were also there, Mr.
My lord, I am there. My lord, I am here, my lord.
No, not today. I am asking about whether on the previous date, 18th.
On the last date, I am there.
Yes, my associate counsel was there.
So, in fact, on 20th December 21,
yes, madam.
This court clearly recorded a prima facie view of the matter, and lastly, you had taken time to substitute one of the petitioner.
Yes, my lord. Yes, my lord. That substitution has taken place, my lord. We have filed wakalatnama also.
So, better you pursue your matter wherever the contempt lies. This court has expressed it.
केवल हुजूर हम 2-3 सबमिशन करना चाहते हैं, subject to my lord's appreciation.
I have disclosed my mind because I have recorded in the previous order of 20th December 2021.
Yes, my lord. Yes, my lord.
If you still want to make submission, I will not stop you. That is not in my nature. But
my lord, I am aware my lord's view, my lord, and I am also agreeable to my lord's view, my lord. My humble submission before this honorable court is only, my lord, to certain paragraphs of the writ court's order, my lord. My lord, paragraph number 2.
Mr. Tiwari,
my lord,
perhaps you have still not appreciated the observations of this court on the 20th of December, that you cannot take out one paragraph or of an order which has stood modified by virtue of the order passed by the appellate court. Now, the order doesn't stand as it is. Maybe some observation of the learned single judge may not have been explicitly differed with or commented upon, but at the end, if the dismissal is not simply per se limine of the LPA, and the learned division bench has said something, modified the writ court's order, then the writ court order cannot be executed in the presence of the division benches. That's
My
the
lord,
point.
in that case, my lord, my humble submission, my liberty may be given to me, my lord.
And of course, the order of the court will not remain uncomplied. The only question is this court's order or the division benches order.
मतलब केवल हुजूर हम केवल फैक्ट्स में थोड़ा सा बताना चाह रहे हैं बिकॉज द फॉरेस्ट प्रोसीडिंग हैज बीन initiated and the order of the Jamabandi is cancelled, my lord. During the pendency of the writ petition, they are coming in the counter affidavit. My lord, para 2 and onward, my lord, they are started fencing my land for the purpose of measuring the area of police line, my lord. Thereafter, it is a case of forceful eviction, my lord. The riots, they got share in the partition suit of 17 of 1941, my lord. My lord, 1941, they got the partition, the property, my lord. Thereafter, my ancestor was purchased, my lord. Para 2 and onward, it is recorded, my lord. And my lord, these poor villagers, my lord, they are agricultural laborers, my lord. They are having a small piece of land.
Not going to change my view.
My lord.
The petitioner, deceased petitioner number 2 has been substituted and has entered appearance through Wakalatnama. As per Land Counsel for the petitioner, Mr. Amit Kumar Tiwari. Stop. Reference may be made to the order dated 20th December 2021, which reads as under. Since it appears from the perusal of the order passed in appeal by the learned division bench that the order of the learned writ court stood modified in
Para 6 and 7, my lord.
in its operative effect, operative portion. The proceedings for initiation of contempt of the writ court's order may not lie before this court. Stop. Learned counsel for the petitioner then seeks liberty to approach the learned division bench for non-compliance of the order passed by non-compliance of the order and judgment passed by the latest patent court. Stop.
As well as, my lord, the single judge also, my lord, because the honorable division bench, my lord, has not, my lord, the satisfied or annul the order of the single judge, my lord, honorable single judge, my lord. Para 5, my lord, para 5 and 6, my lord.
You see, Mr. Tiwari,
My lord.
perhaps you have still not understood.
My lord.
This court will not bind or expand the hands of a division bench of the court. This court will only say that the matter lies there. There you convince. Stop. It goes without saying. The contempt petition is accordingly dismissed as withdrawn.
Lord, may disposed of, my lord. It may disposed of, my lord.
Contempt, if it doesn't lie here, then how will it be disposed of? It can only be pursued before the proper court. Na? So, unless it is withdrawn or dismissed, it can't be pursued. this court is not entertaining the contempt petition. So either I can say it is not maintainable before this court, I will dismiss it, or you will withdraw it to pursue. Doesn't make much of a difference. You have got the liberty.
Item 9, contempt civil 895 of 2018. Mr. Mukesh Kumar for the petitioner, Mr. Amin Kumar Das for the opposition.
I am for petitioner in this.
Yes, Mr. Mehta, perhaps.
Yes, it was. We have filed a show cause. We have also passed a reasoned order in terms of the order passed by the Honorable Single Judge. I do not know whether it is there on your Lordship's file or not. It was filed on 2nd of March, my Lord.
No, not come.
I have served copies upon the petitioner. He must have received it.
Counsel, are you having the copy of the show cause containing the reasoned order?
My lord. But my lord, I'll file reply to so cause.
No, if your claim has been rejected, then they were directed to consider the case and take a fresh decision. So if the case has been rejected, that can be a subject matter of examination on merits in a separate proceeding. So what is the purpose in filing a reply? The sooner you take the liberty and approach the appropriate court to challenge it on merits, the better.
Then my lord, this may be disposed of with liberty to file afresh.
That is what the court is going to do. Mr. Kumar Mehta, then counsel for the CCL, submits that the claim of the petitioner has been rejected by passing a reasoned order on
26 to 22.
26 February 2022, which has been brought on record through supplementary show cause filed on 2nd March 2022. Stop. Then counsel for the petitioner seeks liberty to assail the order of rejection, reasoned order of rejection in an appropriate proceeding. Stop. With the aforesaid liberty, the instant contempt petition is disposed of.
Okay.
Item 10, contempt civil 407 of 2019. Along with
In these three cases, my lord, last Friday, my lord, granted time to file an affidavit in details of the steps have been taken, my lord, for the purpose of complying the order of this honorable court, my lord. Now, my lord, yesterday evening I have forwarded a letter, my lord, on instruction by the additional chief secretary. The deputy director, my lord, has informed in the evening that after receiving of the concurrences, my lord, the receiving of the requisition by the concerned universities, the concurrence of the personal, finance, and the concerned minister are yet to be taken, and thereafter it shall be forwarded to the cabinet, and entire exercise shall be completed within 8 weeks, my lord.
So, again, the court answer would be the same.
नहीं कंकरेंस अभी नहीं लिया गया हुजूर, लेटर में साफ है। अतः विभाग के मंत्री, कार्मिक, प्रशासनिक सुधार और वित्त विभाग तथा अंततः मंत्री परिषद का अनुमोदन लिया जाना है, जिसके कारण उक्त मामले में समय लगने की संभावना है। बट टेलीफोनिकली मतलब ऑन इंस्ट्रक्शन द डिप्टी डायरेक्टर इन्फॉर्म दैट विदिन 8 weeks द एंटायर एक्सरसाइज शैल बी कंप्लीटेड।
So Mukesh Kumar Sinha, why is the opposite party not able to give it on affidavit?
मतलब वो खाली बजट सेशन के कारण एफिडेविट में करके दे रहे हैं आपको।
The other additional chief secretary appeared in the morning despite the budget session.
जी।
This additional chief secretary, he is more occupied.
No, my lord. Therefore, he, my lord, instructed the deputy director to at least inform through letter.
Where is the affidavit containing all those? You want the court to every time, on every date, keep on observing against the opposite parties.
Actually, the concerned
Last date's observations were not enough.
that was more than enough, my lord, and I had communicated on 25th itself, my lord. My lord,
Then let the opposite party number 2 appear.
my lord, just
Because if he doesn't have time, even in a week's time, to file a supplementary show cause indicating the details, then he should better appear and explain in person.
Just, my lord, I wanted to clarify on instruction, my lord. After
No question of clarification. It is not a case where the matter has been taken up for the first, second, third, fourth time.
Yes, my lord.
Pending since 2019, and several orders have been passed. The last order of 25th February was the 10th order. So it is not that it's a casual adjournment or an indulgence. The court had been paying so many observations on the last date.
My lord,
Still, your opposite party has not found time to file a supplementary show.
my lord should appreciate, my lord, that all previous orders, my lord, we have complied through affidavits, my lord, bringing on record the order of the Supreme Court. Just, my lord, just because they have just asked me, my lord, asked me to just inform the honorable court that after receiving of the requisition by the universities, उसके बाद हुजूर concurrences अभी नहीं लिया गया है.
Mr. Mukesh, is it necessary to repeat what you have said at the outset? Have I not understood and responded to that observation?
Yes.
Then why are you repeating?
I'll put it on affidavit, my lord. I'll put it on affidavit on by Tuesday, my lord. It will come on Friday, my lord. I'll put it on affidavit. I'll put it on affidavit.
You should have done that. You were facing the court's ire on the last Friday. You should have got it done. What is the fun in facing the court's ire? The opposite party is not present. He doesn't understand. If he doesn't understand, let him be present on the next date.
I'll get it filed, my lord, before Friday, my lord. I'll get it filed before Friday. I'll get it filed before Friday.
Despite sufficient observations made in the previous order dated 25th February 2022, no affidavit or supplementary show cause has been filed by the opposite party number 2. To explain the reasons for seeking further time for compliance of the court's order. This court had also observed that if the opposite party fails to provide sufficient reason for seeking further time, this court may be compelled to seek their presence to explain the delay in compliance of the order under offense. Stop. Mr. Mukesh Kumar Sinha, Learned Senior Standing Counsel number 1, has submitted that instructions have been conveyed through a letter by the Deputy Director of the department to convey to the court that there are concurrences required from different departments. Stop. Such a statement has also not been brought on affidavit. Stop. This court fails to understand the intransigence of the opposite parties in at least explaining to the court the reasons for the delay by way of a show cause or affidavit. Stop. Mr. Mukesh Kumar Sinha, Learned Senior Standing Counsel 1, then seeks 3 days time to file appropriate show cause or affidavit as desired. Time is allowed. Stop. Matter is posted for next Friday. If it is not done, such a show cause containing the detailed reasons explaining the delay and The grounds for which further 8 weeks' time is allowed is to be allowed is filed. The opposite party number 2 shall appear in person on the next day to explain. List the case on 11th March 2022.
Obliged, my lord.
But I appear at the university.
In case there is some communication gap, perhaps from your end with the officers of the government. Otherwise, this kind of a predicament would not be created, and especially in a contempt matter before this court.
I promptly communicated, my lord. There's a reference also of my letter of 25th itself. After the proceeding, after an hour, I just communicated, my lord. But I'll do it, my lord, on or before 11th.
Next.
Item 13, contested 2019. Mr. Subham Misra for the opposition, Mr. Vijay Singh, Mr. Sanjay Pikrova for the opposition.
Lord, we have granted concurrence, Your Lordship, and I have sent the Your Lordship the order granting concurrence, Your Lordship, on the email of Your Lordships.
We have not received any affidavit or
If required, I will file the so cause.
the petitioner has informed that he has been informed that concurrence has been granted.
So now the university has to take out the notification. So how much time do you require, Mr. Mithilesh?
We have 2 weeks time.
Mr. Piprowal, counsel for the JPSC, states on instructions that concurrence has been granted by the commission for promotion of the petitioner to the skill of university professor as per statute. Stop. Mr. Mithilesh Singh, the counsel for the university, seeks 2 weeks' time for the university to issue the consequential notification.
Right.
Matter will be listed on 25th March 2020.
Obliged.
Affidavit showing compliance be filed by the JPSC, the university, and the state.
Obliged.
Item 14, contested 581 of 2019. Outsider for the prisoner, Mr. Manoj Kumar for the
My lord, in this case, I appear on behalf of the opposite parties, my lord. My lord, in this case, the state has preferred an LPA, my lord. The LPA was listed before the Honorable Division Bench on 22nd of February 2022. My lord, I have sent the order, my lord. And on that day, my lord, the Honorable Division Bench was pleased to direct that the matter be listed before another bench. On which, my lord, one of the Honorable Judge is not a member.
Very well.
And thereafter, it has not been listed.
Mr. Mithilesh Singh, learned GA4.
GA4, my lord.
Submits that the latest patent appeal number 100 of 2021 was taken up by the learned division bench and has since been assigned to another bench on 20th February 2022 and has been assigned to another bench. However, the same has not yet been lifted before any other court, any other bench. Stop. Therefore, he seeks time to take steps for four weeks' time is allowed for the purpose. Stop. Matter be listed on first of April 2022 or 8th of April 2022. 8th April.
Obliged.
LPA was taken up on 22nd, 22nd
Yes, 20 February 2022, LPA was taken.
of that.
Item 60, contempt civil 960 of 2019, Mr. Mahesh Tiwari for the police matter.
क्या रोज आवाज होता रहता है? अभी तक आपको नहीं पता लगा पाए। हाँ, तो उसका कुछ उपाय करवाइए। Every day this disturbance is going on. So,
Yesterday, SOCOS has been sent, also to the last order.
I mean, habit of filing it on the last penultimate day.
We are also under facing such problem, Milord.
So, the system won't change.
Milord, we are trying, Milord, 24 into 7, Milord, we are working. To some extent, we are able to improve, Milord, but still more improvement is required.
Every party has to pay to his counsel for
Yes.
So, what is the affidavit about? So, should we?
Milord, the earlier affidavit was withdrawn, Milord, and fresh affidavit has been filed. Milord, as per the previous order, your Lordship had directed to Milord file the affidavit with approval of the Chief Secretary and Milord the Additional Chief Secretary. So that was filed, and that was last date on Milord, it was withdrawn, and the present affidavit has been filed. So Milord, same extent has been reiterated in this Milord affidavit. So the Milord actually Milord, they want a order of your Lordship Milord on this SOCOS.
Order to what effect? The court hardly comes in between. The
Milord,
court has only wanted
with regard to compliance of section 3G3, Milord, though there is no notification admittedly, Milord, but a stand which the state is taking, that in all the acquisition proceedings, Milord, they are following, Milord, the same procedure. So, following the procedure, Milord, in one case, that may, Milord, make all the acquisition proceedings, Milord, that will be, Milord, the difficulty before the state. So, if your Lordship may pass some order, Milord.
Why is the state apprehending that some difficulty or some serious trouble may arise because they have not been complying the procedure in respect of every other case, and in this case they will have to comply? No one else has come out and complained that you have not complied. People have accepted the report. Then, so it is very difficult to commit a mistake and own it up.
Yes, Milord.
That's the main problem. Nobody is going to come and accuse you or seek a perhaps annulment of the entire acquisition proceedings on that ground. People have accepted it. They might have waived off that objection. But this is the main reason that the concerned officials do not want to tell them. There is no easy way out. When you commit a mistake, you should have the courage to own it up and to correct itself.
Actually, Milord, what they are saying, Milord, that there is no requirement of paper publication so far 3D is concerned. So 3D, Milord, a publication. In all the cases, they have treated it as Milord as a Milord compliance of Milord the procedure. Though Milord 3G, I also Milord I agree, Milord, that I cannot treat 3D as 3G.
For the officers to understand each and every provision and procedure, whether 3D notification is required or not. They may not have understood the correct proceeding of a land acquisition proceeding, procedure of a land acquisition proceeding, but those things are not before us. Na? The only thing is that here that procedure has not been done. And you see, the court has been very steadfast, as you must have noticed in other cases also.
My lord, my lord.
So it is proper to own up your mistake and correct it. पहले के जमाने में नहीं होता था, लोग तपस्या किस लिए करते थे? पश्चाताप करने के लिए।
पश्चाताप करने तो हम लोग तो we are always ready to do पश्चाताप।
हाँ, so
लेकिन हमारे
you are there to advise them how to comply and how to.
If your lordship wants, your lordship can deliberate with them also.
No. Why should I? When you are the spokesperson of person, lawyer, respected lawyer, to speak on their behalf, we'll keep it on next Friday. But tell them that there is no easy way out of things, no shortcuts.
My lord.
And the petitioner is ready and willing to appear and cooperate. So the whole confusion has, it seems, been only at the end of the officers. Some valuation earlier wrongly done, some thing ever done. The petitioner doesn't say that you pay me beyond what is permissible in law. At least Mr. Tiwari has not said like that. Though may have thought that she might get a compensation for some building also or something which may not be falling in the acquisition area. Those are expectations, false expectations. Whatever is due, only that land loser will get as per law.
Lord, let it be in the next week, Lord. I will try again, Lord.
So they should not precipitate things. You see, I have appointed an amicus curiae. I have already, by previous order, asked the Chief Secretary and the Land Reform Secretary to look into the matter. So, if the reticence on the part of the officials goes beyond a point of no return, then there might be more serious action for that. There's always a time to correct yourself.
My lord.
Supplementary show cause has been filed by opposite party number 4.
On behalf of Milord Deputy, I am Milord Secretary Department of Revenue, Milord, on behalf of.
On behalf of the Secretary Department of Revenue, Land Reforms and Registration, Government of Jharkhand. The previous order dated 4th February 2022. Stop. Let it be placed on record. Matter be posted on next Friday.
Item 70. Transportation Civil 14 of Jharkhand. Mr. Pankaj Kumar Mishra for the listener. Mr. Sadhu Prasad for
My lord, at the outset, just a minute. At the outset, I beg to inform this honorable court, my lord, that there is a now serious talk of compromise, and probably on 8th of this month, they will be sitting for a compromise.
They would be seeking 3 weeks' time to bring on record the compromise.
They will be sitting on in presence of the respectable persons of the society, my lord, and they are expecting to arrive at some compromise, my lord.
Petitioners Council, you wanted to say something?
My lord, अगर compromise हो जाए तो हमको कोई आपत्ति नहीं है.
हम लोग हालांकि जालसा में बहुत कोशिश किए थे सर, जालसा में नहीं हो पाया, लेकिन सोशल
एक opportunity दे दिया जाए.
दोनों को सोशल प्रेशर पड़ रहा है, इसलिए 8 तारीख को है बैठक रखा गया है.
Mr. Sarju Prasad, learned counsel for the opposite party, submits some instructions that the talks for out-of-court settlement of the matrimonial dispute between the parties is still underway after failure of the mediation. But mediation exercise, but stop. Therefore, the matter may be adjourned for 3 weeks.
3 weeks there be sir.
3 weeks. Mr. Pankaj Kumar Mishra, learned counsel for the petitioner, also submits that there can be no better result than an amicable settlement between the parties. As prayed for, lists the case on 1st April 2022.
Obliged.
Item 18, Transport Business Bill 24 of 2020, Mrs. Sabasati for the
May I please, Your Lordship? Your Lordship, I have filed my reply, Your Lordship.
Mr. Sabisachi, you are appearing. Yes, what does your reply say about the address portion?
Your Lordship, I have annexed, Your Lordship, that starts from the page number 7, Your Lordship. Your Lordship, petitioner has done her educational, Your Lordship, education from the Ranchi itself, Your Lordship. She has voter card. She has, Your Lordship, Aadhaar card. Her father's, Your Lordship. She has her driving license. Your Lordship, voter ID card, Aadhaar card, her father's, Your Lordship, electricity bill, and Ranchi Municipal Corporation's, Your Lordship, holding tax. Everything is of the Ranchi, Your Lordship. I don't know, from there they have cooked the story that they belongs to Bokaro and her educational qualification has been done from the Bokaro itself. Your Lordship. I have annexed her intermediate, Your Lordship, admission card. Ranchi call her graduation, Your Lordship, admit card, marks card of her graduation. Thereafter, driving license of petitioner, Your Lordship. In the driving license, Your Lordship, in the bottom address is Suripuri, Hehal, near Piska Mode, Ranchi. Voter ID card, Your Lordship, the same address, Ranchi, Sukhdev Nagar. Aadhaar card, Your Lordship, Suripuri, Hesal, Ranchi. Electricity bill, Your Lordship, which is generated in the name of petitioner's father, and Your Lordship, holding tax, Your Lordship.
Yes, Mrs. Shalini.
Your Lordship, nothing left, Your Lordship. Whatever falls from Your Lordship without giving my consensus.
You should have told your client not to make statements.
No, we have. Yes, Your Lordship. They said that this was in their knowledge, as was disclosed. What it was all what he said, Your Lordship. There is nothing on record, so I cannot vouch for it.
If you put it on an affidavit on behalf of your client, the client should have responsibility for it. It should not be a casual statement made.
No.
Consumed time, the other party has been put to test, which she has obviously successfully cleared. Otherwise, this could have led to serious consequences for her.
Your Lordship.
Similar consequences for the person who states that otherwise.
I understand, Your Lordship.
Third learned counsel for the petitioner, Mr. Sabisachi and Ms. Swati Shalini, hearing for the opposite party. Petitioner White seeks transfer of original suit number 269 of 2020 under section 12(1) small b of 12(1) small b of the Hindu Marriage Act 1955 by the opposite party for declaration of the marriage as nullity from the court of learned family judge and from the learned family court Dhanbad to the learned family court Ranchi. Stop. Petitioner's marriage with the opposite party was solemnized on 22nd November 2019 at Dhanbad. Stop. Thereafter, marital discord grew and she filed a complaint case before Learned Judicial Magistrate First Class at Ranchi bearing number 3297 of 2020. Opposite party, on the other hand, filed a suit for restitution of conjugal rights under Section 9 of the Hindu Marriage Act. No, the petitioner filed suit for restitution of conjugal rights being matrimonial suit number 224 of 2020 before Family Court Ranchi, which is pending. Stop. Petitioner has, in reply to the counter affidavit, enclosed her certificates of educational qualification and ID proof, Aadhaar card, etc., to substantiate that she has always studied at Ranchi. She has completed her educational career at Ranchi and her address is also of Ranchi. Permanent address is also of Ranchi. Stop. Therefore, in the absence of any source of income, she may not be able to contest this suit at Dhanbad. Attend to the suit at Dhanbad, matrimonial suit at Dhanbad, which may remain uncontested. Stop. Wherefore, transfer of the suit has accordingly been made. Stop. Then counsel for the opposite party has opposed the prayer. Stop. A counter affidavit was also filed earlier, in which land averments were made without supporting document that the petitioner has always studied at a place 20 kilometers from Dhanbad and has, by suppressing these facts, sought transfer of the case to Ranchi. Stop. However, these averments stand specifically denied by the petitioner through supporting documents. Stop. On consideration of the rival submission of the parties and the materials on record, this court is therefore inclined to allow this petition, since it appears that petitioner has worked out a prima facie case and balance of convenience also lies in her favor. Stop. If the suit is not transferred, she may not be able to properly contest it in the for lack of enough financial resources and the two places being separated by considerable distance. Stop. Accordingly, let so and so suit be transferred from the court of so and so to the court of so and so forthwith. The petition is allowed.
Lord, in this case, I am appearing for the petitioner.
Yes.
We have prayed for transfer of the MTS number 26 of 2020 from Family Court of Hazaribagh to Ranchi Mirror.
The other side has not appeared despite valid service of notice and indulgence granted.
Yes, my lord. No one appearing.
Learned counsel for the petitioner. Opposite party has not entered appearance through wakalatnama despite valid service of notice and indulgence granted on the previous date. Stop. Petitioner wife seeks transfer of MTS number 26 of 2020 from Learned Family Court Hazaribagh to Learned Family Court Ranchi. Stop. According to the petitioner, the marriage between the parties was solemnized on 9 July 2018
Lordship,
as per Hindu rites and customs at Ranchi. Stop. Despite sufficient dowry and
Your Lordship, I am in item number 21, Your Lordship.
mute kariye. Your case has not been called out. She was treated with cruelty by the opposite party and also physically assaulted. She was forced to leave the house and thereafter suit under section 9 of the Hindu Marriage Act has been filed by the opposite party for restitution of marriage. Stop. It is submitted that the petitioner is not in a position to contest this suit at Hazaribagh as she is residing with her old age parents at Ranchi and the two places are separated by
Milord, Itki, Ranchi, Itki, village Itki.
village Itki, Ranchi, and the two places are separated by sufficient distance. She doesn't have enough. And she is dependent upon her parents and has no independent source of income. Stop. Therefore, the suit may be transferred to the competent court at Ranchi from Hazaribagh. There is no opposition to the prayer since opposite parties has not chosen not to appear despite valid service of notice. Stop. I have considered the submission of learned counsel to the petitioner and the grounds stated in instant petition. Stop. On being satisfied thereof, the court is inclined to transfer the matrimonial suit number so and so from the family court Hazaribagh to the learned family court Ranchi. Stop. Accordingly, it is ordered so.
Much obliged, Milord.
Item 20, Transportation Civil 26 of 2020. Will Kumar.
Milord, in this case, I am appearing for the petitioner, Milord. Milord, I had applied for the certified copy of the FIR, Milord, but due to some problem in the copying section there, Milord, certified copy was not made available by yesterday also, Milord. It will be get available tomorrow, Milord. Although I have sent, Milord, in the Milord, your Lordship may kindly peruse page 12 of the Milord, the claim petition. They have given their permanent address, everything they have given, and I have sent the copy of the FIR, Milord, before your Lordship, Milord, in which the son, one of the claimant, has filed the FIR, Milord. Your Lordship, page 12, Milord, of the claim petition, Milord, running page 12. Milord, column 4, Milord, permanent address. And I have sent also the Milord, the FIR, Milord, copy of the FIR that received under police paper, Milord, in which the informant, who is the son of the one of the claimant, who is the son of the deceased, has given his address. He has said that his father is running used to sell milk, Milord, and was going from home for selling of milk.
So you bring on record the copy of FIR.
Yes, because copy was not made available. Some technical fault was there in the copying section yesterday, Milord. It was applied last Saturday only, but therefore, Milord. Next Friday, Milord. Next Friday, it may be by today we will receive the copy, Milord.
The request of learned counsel for the petitioner, Mr. Ravin Kumar Chaudhary, matter is passed over for the day to bring on record the copy. As he submits that certified copy of the FIR has been applied for and would be brought on record before the next date.
Item 21, Jharkhand National Civil, 14 of 2021, Mr. Vijay Kumar Sarkar for the petitioner, Mr. Anil Kumar Sinha for the petitioner.
Yes, who was speaking in the midst of the previous case? Anyone appearing? Miss Niru, you are not on the screen, so
Your Lordship,
network
I am on behalf of respondent, Your Lordship.
you have to come on the screen to address the court. Have your network proper.
And I am praying for for the day in this case, Your Lordship.
I appear on behalf of the petitioner, Your Lordship.
There is poor network connectivity at both ends of the respective councils.
Transfer for the
matter is
Jamshedpur to Chhatrai, Your Lordship.
passed over for the day, Mr. Sharma.
Other side, appeal.
I am not able to hear both of you because of the network issues at your end. So passed
Yes, Your
over.
Lordship. Lordship, I am on the screen, Your Lordship.
Very well, I have seen you, but your network is not proper, not able to hear you properly at this end. Passing it over as you had requested.
Item 22, Transportation Civil, 15 of 2021, Mr. Indrajit Sinha for the petitioner, Mr. Samir Saurabh for the petitioner.
No, Your
My Lord, I am appearing petitioner lordship. There is a compromise talk is going on between the parties, so I am just praying that after the holy vacation, your lordship.
Yes, my lord, there is a negotiation is going on between the parties, lordship. So 2 weeks will be sufficient,
Please
lordship.
submit that talks for
And
amicable.
meanwhile, my prayer, Lordship, earlier that the matter was heard,
करिए
Your
ना
Lordship.
आप. When your case is over, how can you keep interrupting in between? Then counsel for the parties submit that talks for amicable settlement of the dispute is going on. Stop. Therefore, the matter may come up after holy vacation, holy holidays. List the case on.
Obliged.
Obliged.
Item 23, Transportation Civil, 90 of 2021, Mr. Majumdar for the petitioner, Mr. Dhananjay Bhatt for the.
Your Lordship, I am appearing in this case. Your Lordship, on the last date, my learned friend has said that he has cooperated in the mediation, Your Lordship. So he has been asked to file the affidavit to that effect. Because as per mediator, he has not appeared, Your Lordship.
Lordship, I have filed supplementary affidavits, Your Lordship. I am appearing on behalf of the opposite party, Your Lordship. In para 4, Your Lordships, before going to the supplementary affidavit, Lordship, kindly come to the order of 17/12/21, Your Lordship. Para 4 in supplementary affidavits, Your Lordships. मैं जाती हूँ.
Have you got a copy of this order, Mrs. Majumdar? A copy of the supplementary affidavit?
Your Lordship, I got that copy of the
Okay.
I got
Have you gone through the statements made? Yes, any councils, if you have to make any submissions?
Yes, Your Lordship.
Your Lordship, on the last mediator said that he has not, before the mediator, Your Lordship. The learned friend has said, submitted to Your Lordship, that they have appeared. But now in the affidavit, they have said that he has not appeared, Your Lordship. Now, the case was sent for mediation, Your Lordship, because he has filed a divorce. There are a number of litigations pending between the parties. And he has remarried also as per my party instruction, Your Lordship. So I asked party him divorce. There's no point in going for litigations, Your Lordship. That's why the case was sent for mediation. If my learned friend wants divorce also and to harass me also, Your Lordship, then I'll pursue this my transfer application, Your Lordship. Because he has filed a divorce. Initially, he has filed Section 9, Your Lordship. That was transferred from Latehar to Ranchi, Your Lordship. But subsequently, he has withdrawn that Section 9 petition, Your Lordship. And he has filed this divorce application. Now, divorce me, Your Lordship, because they are the chief sister.
That Section 9 petition was transferred by order of this court.
Yes, Your Lordship, by Your Lordship's order.
Coordinate bench, Your Lordships, by Honorable Mr. Justice H.C. Misra, Your Lordships. So far as para 10 of learned friend petitions, Your Lordships. Para 10 of transfer petitions, Your Lordship. Kindly come to the para 10. False affidavit given by petitioners here in before my lord courts, Your Lordship. Para 10 of transfer petitions, Your Lordship. That petitioner has said that, in fact, it was not in the knowledge of the petitioners that opposite party has filed case under Section 9 of the Hindu Marriage Act before the learned principal judge family court, Ranchi, and no notice had been received by the petitioners. And petitioners has filed transfer petitions before my lord court, and that case was transferred from Latehar to Ranchi, Your Lordships. How the petitioners has said that there was no knowledge.
Notice has not, by mistake, it's Ranchi. No.
I have annexed the orders, Your Lordships. I have annexed orders in our replies, Your Lordship. Para 7 of our petition. Para 7 of our petitions, Your Lordship. And first of all, Your Lordships, I am our much contentions, Your Lordships, how time and again said that opposite party has remarried. My lord may get affidavits in this regards from the petitioner side, Your Lordships. कोर्ट को मिसगाइड करते हैं बार बार कह करके ये सब. Last time I was also submitted before my lord, Your Lordship. Take Lordship kindly take affidavits from the petitioner side, Your Lordship.
Your Lordship, time since he is a practicing lawyer in Latehar, he keeps on filing complaints.
Practicing lawyer है तब भी मार खा जा रहे हैं. Practicing lawyer है और मार खाते हैं पुलिस थाना सब.
Don't keep on arguing like this. Wait till the court asks you a query. This is not a simultaneous argument from both sides. I am not able to understand and appreciate. Heard learned counsel for the petitioner and Mrs. Jaswinder Majumdar and Mr. Nandan Prasad appearing for the opposite party. Stop. The present petition is by the wife seeking transfer of original MTS within bracket suit number 11 of 2021 instituted by the opposite party husband for a decree of divorce under section 13 of the Hindu Marriage Act 1955 from the court of Learned Family Court, from the Learned Family Court Latehar to the Learned Family Court Ranchi. Stop. It appears that earlier the opposite party had preferred a matrimonial suit for restitution of his conjugal rights before the family court Latehar, being original suit MTS number 17 of 2018. Stop. The same was transferred at the instance of the petitioner wife by order dated 11th April 2019, passed in transfer petition civil number 60 of 2018 by a coordinate bench of this court, taking note of the fact that the opposite party had no objection in transfer of the case from Latehar to Ranchi. It appears further from the records that it appears that from submission of learned counsel for the parties that the said proceedings have been withdrawn and the present suit has been instituted for divorce by the husband. Stop. The marriage between the parties was solemnized on 28th April 2015 as per Hindu rites and customs. Stop. Petitioner has subsequently instituted a case under Section 498A of the IPC and read with Section 3/4 of the Dowry Prohibition Act, being Mahila PS case number 31 of 2018 at Ranchi. Stop. Which is pending. जहाँ विड्रॉल का लिखे थे वहाँ ऑर्डर कल लिख दीजिएगा Annexure 3 order dated 26 February 2020 passed by Learned Family Court Ranchi in original suit number 285 of 2019. Stop. Then counsel for the petitioner submits that as a condition of grant of anticipatory bail passed by Learned Judicial Commissioner Ranchi in ABP number 2192 of 2018. Opposite party has been directed to grant interim maintenance. Stop. Petitioner is totally dependent upon their father or her father, and she has 3 more sisters, one being married and 2 others are studying. Stop. She has also one younger brother who all are dependent upon his father, who is a bank employee. Stop. She has genuine difficulty in attending to the proceedings of the suit at Latehar, which is an interior place of the state, and to come back on the same day. Stop. As such, she may not be able to properly contest the suit. The suit may be accordingly transferred to Ranchi. May therefore be transferred to Ranchi. Stop. Opposite party has filed a counter affidavit. Stop. And then counsel for the opposite party has taken a plea that the earlier averments made in relation to filing of the case under Section 9 of the Hindu Marriage Act at Family Court, averments made regarding lack of notice of the suit instituted before Family Court Latehar under Section 9 of the Hindu Marriage Act by the opposite party in the main petition is incorrect, as at her instance the suit was transferred to Ranchi. Stop. Petitioner has, without any valid reason, refused to stay with her husband, which is evident from the order dated 11 December 2019, passed by Learned Family Court, Ranchi. In the original maintenance case number 310 of 2018. Stop. Further, petitioner has filed a false case, criminal case, before Ranchi Mahila Police Station. Stop. Opposite party has his legs fractured on 15th May 2021 and cannot properly move anywhere. Stop. That is the reason why he could not attend the mediation proceedings physically at Jhalsa. Stop. According to the opposite party, there was no non-cooperation on his part in mediation proceedings, which he had expressed to attend online. Stop. Our mediation proceedings have remained a non-starter. Stop. It is submitted that the suit, if transferred to the Family Court Ranchi, may not be properly, a petitioner may not be able to properly prosecute this suit if transferred to Ranchi because of his the fact that petitioner's leg was fractured earlier. Stop. I have considered the submission of learned counsel for the parties and taken note of the pleadings placed from the records. Stop. It appears that on account of marital discord, petitioner has instituted a criminal case at Ranchi and is residing with her father at Ranchi. Stop. It further appears that though the maintenance case was dismissed by the Learned Family Court, Ranchi, but petitioner's contention that she doesn't have independent source of income doesn't stand refuted by the opposite party by any statement to that effect. Stop. Earlier, the petition under Section 9 of the Hindu Marriage Act instituted by the opposite party was transferred to Ranchi from Latehar without any objection from the opposite party, pursuant to the order passed by coordinate bench of this court. Stop. Taking into all these facts and circumstances, this court is of the opinion that petitioner, who is dependent upon her father, may find it onerous to attend to the proceedings of the suit at Latehar, which is an interior place of the state, and also come back on the same day. If the suit is not transferred to Ranchi, she may not properly be able to contest it. Therefore, the petitioner has made out a prima facie case for transfer of the matrimonial suit number so and so from Learned Family Court Latehar to Learned Family Court Ranchi. Stop. Let the records of so and so be transferred from so and so court to so and so court forthwith. Application is allowed.
One more submission may be recorded, Your Lordship. One more submission may be recorded, Your Lordship.
Yes.
Opposite party has reasonable apprehensions that if he has come in Ranchi, he may be murdered, Your Lordship. So, as because I have filed annexure 3 that in थाना में भी उनको मारपीट किया गया है, जो उसके लिए हम फाइल किए हैं कंप्लेंट केस before learned lower court, Your Lordship. I have filed annexure 4, Your Lordship.
Mr. Nandan Prasad, Land Counsel for the petitioner, opposite party, also submits that opposite party, Mr. Nandan Prasad also submits that the opposite party has genuine apprehension of being harmed if he is made to come to Ranchi to prosecute the suit before Learned Family Court, Ranchi. Yes.
Item 24, transfer this 7 of 2021, Mr. Nitish Kumar.
Yes, my lord. I am appearing on behalf of the petitioner, my lord. This application has come first time, my lord, for transfer of matrimonial suit from Dhanbad to Jamshedpur, my lord.
Issue notice on the opposite party under registered cover with AD, speed post and ordinary process, for which requisites be filed within 1 week peremptory.
Much obliged, my lord.
Item 25, transportation civil 42 of 2021, Mr. Kumar Nilesh for the petitioner.
Lordship, in a present case, the petitioner is seeking a transfer of a divorce suit, Lordship, filed at Galwa. The main ground.
Counter affidavit, Mr. Devesh.
Yes, Lordship, I filed on Wednesday. I put it on the box, Lordship. May I submit one thing, Lordship? Today, the mediation is going on between the parties, Lordship, in Dhanbad Family Court. So I pray that it will be taken after a week, Lordship.
Counter affidavit has been filed in the drop box by Learned Counsel for the opposite party yesterday.
No, on 8th, Lordship, 8th.
8th, matlab?
No, on Wednesday, Lordship. On 2nd, Lordship, 2nd.
22. Let it be placed on record. Learned Counsel for the opposite party further submits that mediation is going on between the parties before at Family Court Dhanbad.
No, Lordship, I don't have any such information.
Therefore, the matter may be adjourned for some time. In that view of the matter, let the case appear on 25th March 2020.
Item 26, transportation civil 45 of 2021, Mr. Nitish Kumar for the petitioner.
Lordship, I am appearing on behalf of petitioner, Lordship.
Your Lordship, I am appearing on behalf of the opposite party, Your Lordship. I pray
Lordship, pray for mediation, Lordship. Matter may send for mediation before.
Earlier counter affidavit, Mr. Pandey had sought time to file counter affidavit. It has
Your
been
Lordship, the husband was suffering from some ailment, Your Lordship. Therefore, we were unable to file. But we will be filing in a week, Your Lordship.
Pray for
Are you able for mediation as petitioner's counsel is proposing?
Your Lordship, yes. There is no specific instruction with respect to this, but I don't think so there will be any problem with that.
No, is he employed? Where is he living? Whether he will be able to come physically to Jhalsa to attend mediation proceedings on the
Next
dates?
week he is coming up, Your Lordship, for the filing of the counter affidavit, and if
date is fixed. I'll ask him to come on that particular date itself.
Very well. Then counsel for the opposite party submits that counter affidavit would be filed in the next week. Stop. He also agrees to the request of learned counsel for the petitioner that the parties may be referred for mediation to find at Jhalsa to find out an amicable settlement of their matrimonial dispute at this stage. Since their marriage is of only 10 years old, and there are 2 children born out of the wedlock. Stop. Parties are willing to attend mediation physically at Jhalsa.
Lordship, before Jamshedpur, Dalsa, Jamshedpur.
Let the parties, Jhalsa already, let it be at Jhalsa.
Okay, Your Lordship. And in the meantime, stay, Lordship.
Accordingly, let the parties appear before the learned member secretary Jhalsa on 12th March 2022 at 10:30 a.m. Stop. Learned member secretary Jhalsa can also be approached on the following numbers. On their appearance, matter be placed before the learned mediator for undertaking the exercise. Stop. Parties should cooperate in the mediation proceedings and attend each of the sittings with an open mind. Stop. Opposite party shall pay a sum of rupees 1,000 to the petitioner on each date she attends the mediation proceedings, in the presence of learned mediator Jhalsa towards travelling and incidental cost. Stop. If the parties are able to arrive at an amicable settlement, terms and conditions thereof be reduced in writing under their joint signature and be submitted along with the report 4 weeks thereafter. The matter be listed on 22nd April 2022 along with the report. In the meantime, further proceedings in original matrimonial within bracket suit number 43 of 2021 pending before learned Principal Judge Family Court at Chaibasa shall remain stayed.
Obliged.
Notice.
Item 27, Council Civil 51 of 2021, Mr. Ravi Kumar for the petitioner.
Your Lordship, in this case, I am appearing on behalf of the petitioner. This transfer petition is coming for the first time.
Very well. Issue notice on the opposite party and the registered cover with heading speed post and ordinary process for which requisites be filed within 1 week peremptory.
Obliged.
Item 28, Council Civil 52 of 2021, Mr. Ram Shekhar for the
Lord, in this case, I am appearing for the wife petitioner. The petitioner has paid for the transfer of the original suit, Lord 116 of 2021, from Sahibganj to Lord Pakud.
Issue notice on the opposite party and the registered cover with heading speed post and ordinary process for which requisites be filed within 1 week peremptory.
Lord.
Item 29, Council Civil 293 of 2021, Mr. Ravi Kumar for the petitioner.
In this case,
Yes.
the order is not annexed 1.
Mr. Shahni, you will take it up in the next Friday because today the reference is there.
It will take some time, Lord.
So passed over for the day.
Yes.
Item 30, Council Civil 684 of 2021, Mr. Ravi Kumar.
This is coming for first time. Who is appearing for the opposite party?
It is first. It has come, Lord, for the first time, Lord.
So opposite party, who is appearing? This is
There
from
is
CCL.
Lordship, I am appearing on behalf of
CCL is the party, Your Lordship. Okay, number 2 is the CCL, Your Lordship.
So who is appearing? Brother, sorry, just a minute.
Okay.
Who is appearing for the opposite party?
Name is not appearing of any of the counsel for the CCL, Your Lordship.
Counsel for the petitioner, Mr. Ajit Kumar, undertakes to serve copy of the pleadings on the learned counsel for appearing for the opposite party CCL by
Yes,
Monday and file thereof in the registry on the same day, so that the name of learned counsel for the opposite party of CCL be reflected in the cause list henceforth.
yes,
Let the matter appear after 1 week.
on next Friday, possible, Your Lordship.
Next Friday.
Much obliged.
Obliged, Your Lordship.
Shivani Kapoor for the state of Jharkhand. Yes, so brother, switching on to division bench now.
Yes. On the subcommittee for this, under the heading for orders, item 1, criminal appeal DB number 40 of 2020. Mr. Ramesh Kumar for the
May it please your lordships.
Yes.
Lords, the IA has been filed for suspension of sentence. Earlier, the prayer for suspension of sentence has been thrice rejected by this honorable court. But we have renewed the prayer on the ground of Annexure A at page 13. If your lordships may kindly have a look to. The other co-convicts, they have been granted bail by this honorable court on the ground that they have suffered 10 years of custody and there is no likelihood of hearing of the criminal appeal.
Annexure A, yes.
My lords.
And what about the custody period of this appellant?
My lords, he is in custody, he was taken into custody on 9/4/12.
Where are those?
That comes to paragraph 14, my lords, I have stated. Date is not there, but 9 years, 10 months. But my lords, I would add in this that for certain was on provisional bail for treatment of his wife, my lords. That was around 5 months.
So how much is the total period now?
It is, to my calculation, it is 9.5 years.
So then let him complete 10 years.
Lords, so far other considerations.
He enjoyed provisional bail, therefore he missed
Lords,
out on the...
that was on account of illness of his wife, Lords.
True.
And
So
the
actually,
treatment of wife is still going on. And therefore, your lordships may kindly consider this fact. The other persons, that is...
For medical grounds, provisional bail considered granted. Or regular bail, custody complete, then will be granted. Principles are quite clear. Other co-opponents have been granted on 10 years, so let him...
My lords, that is there. That is there. Lords, I was just praying just because his wife is under treatment, some liberty to him with regard to custody. Lords, it is more than 9.5 years.
No, in para 14, he has stated that he has remained for 9 years and 10 months.
My lords.
He has added those 5 months of provisional bail also.
My lords, my lords. Lords, to my calculation, it comes to 9 years, 6 months. Subtracting those period of provisional bail, my lords.
Let him remain for a few more months. Nearing 10 years or 10 years.
Let this IA be kept pending, my lords. We will not press that.
Not pending. Renew it. Prayer for
Again, we will have to file it, my lords. Let it be after. Let it be simply adjourned, my lords. We will not press in between. If it all.
Learned counsel for the petitioner submits. Praise for appellant submits that since the appellant has completed about 9.5 years of custody custody now, though other co-appellants have been granted bail in connected appeal on completion of 10 years of custody. Present matter may be adjourned for the time being. Analogous appeal, criminal appeal DB number 884 of 2014. Stop. Accordingly, the matter is adjourned.
Obliged.
To be listed on IA number 455 of 2022 on being mentioned. Very well, brother. We join after 15 minutes.